Okay, it is about 7:04 p.m. and today is Wednesday, February the 16th, 2022. Welcome to week number 2 of business law, and my name is Richard Wright, and I'll be here roughly for the next hour or so, giving you detailed information about the assignments and requirements for this class for this week. So let's go ahead and get started. I'm going to share my screen. Okay. Let me first of all remind you that assignments for week 1 should be graded by Friday night at 11:59 p.m. Central Standard Time. And you should be aware of the fact that if you have a 0 in there, as of now, it's because your assignment was not completed by the due date, which was Sunday. And that would have been the 13th. So every Monday I go through and I put zeros behind course classes, rather assignments that are not completed as required by the school for 2 reasons. Number 1, to alert the student or remind the student. And number 2, so that the advisors can see that you did not complete your assignment. And be aware that it's not necessarily a final grade. For discussion posts it is, but not for your written assignments. That means that you can still submit your written assignment, but at the juncture now, if you were to submit it, it would be a total of 30 points off. So if you had 100, the most you could get is 70. If you submit it tomorrow, it's 60. So you see, you understand the reason I'm doing this is because a student wanted to know, they thought it was unfair for them to get a 0 one day after the assignment was late. Well, that student didn't understand the process. That's why I'm doing it, so that everybody understands the process. All professors should be doing it. My dean keeps up with me doing that, as well as, like I said again, I started doing it, but before someone told me about it. So if you have that 0, just be aware that that is not your final grade. But you still have time to submit your assignment with the loss of points. Of course, though, those of you who reached out to me to let me know, like a few people reached out to me to let me know that they had reasons why their assignment was going to be late and they were extenuating circumstances, I responded back to them to let them know that I would give them the extension for whatever, a couple of days, and then they had a chance to submit their assignments. So very, very, very important that you understand that process. All right, so let's take a look at the calendar as a reminder, and put the month view up here. Whoops, month view up here. And you see this is where we are. You see your live lecture this tonight, 7:00 p.m. Central. Your initial post was due yesterday. Your reply post is due Saturday. Your written assignment is due Sunday, along with your live classroom phrase. Those of you who come to the live lecture have an advantage because you can get that in right away. And then once again, as I always do, I remind you of when the class ends on the 18th. That's the last day of class. assignments submitted after the 18th will not be accepted because the school won't let me unless you've made arrangements for an incomplete, but you've got to go through the process of making sure that you do it right. That's located in the syllabus. You can check that out. And then you understand that I'm the one who has to approve it. Okay. So it's good to reach out to me so that I can help you out there. Okay. All right. So there we are there. Okay. So now let's go back to the business law class. Again, these are the students who are in the class. And okay. So now let's get to Module 2 content. Contract law. This is one of my favorite um, weeks because contracts control a lot of business. And we'll talk about that in just a few minutes. So you want to pay close attention to this. First of all, in order to help you, I provided um, some information regarding the statute of frauds, which if you save this sheet, that information, it will be very valuable to help you to remember, to be able to recall. I recall uh, the type of contracts that must be in writing to be enforceable um, because I took the bar exam in 1978 and we studied, and to prepare us for the exam, we was tested pretty heavily on the statute of frauds and when contracts had to be in writing to be enforceable. And uh, we, we, we were given this mnemonic that I'm going to share with you, that I've shared with you through the email. Okay. But first, let's go over the discussion assignment. So we talk about what contracts involve. There are different factors that involve. Some are very simple, but contracts affect the way we operate in our lives. I was very close to the founder of McDonald's as a kid, Ray Kroc, and Mr. Kroc. Uh, the way I knew him was I worked for the law firm that represented McDonald's, and I was a messenger. So I took a package to him one day, and we became friends. After that, he started requesting me, and I went a lot of places with him. Excuse me, and I learned quite a bit about contracts. But one of the things that was interesting about him, I learned, is that he believed in the handshake as the deal. I mean, he had his lawyers. You know, we lawyers don't believe in the handshake. Okay, that's a ritualistic thing. We believe in what we call the four corners doctrine. And that means that if it ain't in the four corners, then it doesn't exist. They have this thing called parole evidence that's a lot of time used to try to clarify a contract, but sometimes you can't use parole evidence. All parole evidence is discussing things that were intended to be in a contract were not in there, but good people don't rely on that. I always tell you the four corners doctrine. If it if it ain't in writing, might be bad grammar, but it's correct, then it doesn't exist. And that's the way it is. And it's important. And what's in writing is what counts. All right. So you're going to research the topic of consumer contracts. And in your initial post, provide an example of a possible agreement. They may involve organizations and individuals. Possibilities include leases, um, phone, internet contracts, even store receipts. Did you not know a lot of people don't realize store receipts are proof of purchase, particularly the credit card ones you get? You notice at the bottom it says that you agree to cover the amount by your signature on the card. But anyway, uh, very important. In your analysis, explain what elements need to be existing for a valid enforceable contract to be in place. That's where our discussion tonight will come valuable for you. And your reply post, which is due on Saturday, consider the agreement that one of your other classmates offer and use their information. You can use Fast Case for legal research, Discovery for articles and ebooks, or you can reach out to our librarian to help you as well. Okay. All right. I see one student who is right here, right now with me, and that's Shannon. And I'll put hers up to show you because I looked at it. Very good. Yeah. Yeah, she covered all the bases. Okay. Yeah, I know about the Verizon. That's who I have as my phone company, and other. And so these are that's good. Excellent. Excellent post. Excellent. Okay. You can respond if you want, or you say nothing. It's in the you can put in the chat. See, you're welcome. I I I like to uh, put my students on parade when I see that they are exemplifying the requirements of the assignment. Excellent. Keep doing that and you get an A in this course. But more importantly, as I say, I'm not a fan of students who come for A's. I'm a fan of students who come for excellence so they can be good professionals. That's what I'm a fan of. That's who I hang with. All right. The written assignment, which is due Sunday, you use this scenario, and then you're going to write a formal business memorandum that addresses the following. What elements would you expect to find in a contract? What type of commonly used contract clauses? What business recommendations would you share with the company as it proceeds? Should it consider accepting the offer? If so, would certain conditions apply? Use proper grammar. Do not copy and paste a contract. Just provide the information. Please, whatever you do, cite your sources for the statements or information that you contain in your paper, along with a reference page and a cover page. It must be a Word document. Very, very, very important. All right. And so we're going to cover quite a bit about that. All right. Oh, let me go back because I got to show you how important it is for your grading that you do this right. Grading rubric. So if you want to get the highest grade, you're going to have thorough and detailed explanation of those points. That includes with citations and sources cited. Same thing with explanations and recommendations and professional tone. Remember, it's in proper APA format. All right. If you don't have citations in the paper, you're going to end up with 55 because it's going to be limited based on not having that. That's where limited comes in. Okay. Unprofessional tone and grammar and so forth. Uh, remember, APA format was not used, or no references included, or no citations included. So right there, I can't put you over there. You end up over here. So students ask me, Why, just by not having citations, do I end up over here? Because it represents limited explanation. Just that one little point. Because remember what we discussed when we talked about the fact that um, um, integrity is involved. Remember how you avoid plagiarism, how you avoid allegations of academic integrity, where you've taken information from some source and not given credit for that source. So that's why it's considered as limited to us. Be aware. That's why grading for in a rubric, and then incidentally, I'm going to show you how where I put your comments. Here we go. In just a minute. I'm going to click over. All right. If you have questions about the assignment, feel free to reach out to me. Now, I'm going to 4-minute leave here and go to the grade book. Now, I'm very cautious about how I do that. Let's go to week 3 assignment, which we haven't done yet. Okay, nobody in here has submitted an assignment, so okay, so it won't let me open up. Okay, so I have to go with one of these. Okay, week 2, let's go back to week 2. Okay, now I haven't graded anything yet because nobody has submitted anything. Let's do better. Let's go back to week 1. That's where I'll find what I'm. Okay, now this is what I'm going to be doing because I have 28 assignments to complete. All right, so now I want to show you. Okay, now let's take this student right here. Now you're not going to see his grade. Obviously, you're going he's already attempted. All right, but here's how it looks. So I click on this, and then the assignment will show up, but then I download it um, after a while. And then here's the rubric. So I go to the rubric. This is how I grade you now. So I go down, I have the paper I've already read. So I look and see if you, in the introduction, you did you have thorough introduction with detailed overview of business and purpose? If so, you'll get 5. But it goes down. If you limit it or basic, then not. Then what I do is I add a remark in here about if you did mastery, I'm not going to have a remark in there. It speaks for itself. But what you did wrong, I will let you know in here. That's how I do it with my students. And you'll see me go down to each section and then it tabulates and adds the points. I don't. So that's how, and like I said again, people say, well, I don't see any feedback. Yes, if you go in your grade book, you'll be able to see the same thing that I see right here, okay, in your grade book. So now you don't have to ask me where is the feedback. Now you know where it is. Okay, so let's get out of the grade book now. Okay, I got one that I graded already. Um, I won't show you it, but that student got a perfect grade. Okay, so now that's I do that because I want students to understand that I grade you based on the rubric. That is why I talk about the rubric so much, so that you understand that. All right, let's look at the announcements. Week 2. Okay, for week 2, let's scroll that down there. We're talking about my favorite topic, contract law. To prepare for this assignment, you read chapters 8, 11, and 12, and I sent you the corresponding PowerPoints for those three as well. And then also um, contract basic elements. We'll talk about each of these sections. Illegal and defective agreements, contracts between partnerships, and other illegal relationships. And then you'll see the flashcards to help you out. This tells you about when the lecture takes place here. This tells you your written assignment, um, well, discussion assignment, consumer contracts, and we already talked about the due date was yesterday for initial post, reply post Saturday, and then and notice to see that right there? Pay close attention to the rubrics. That's the yellow brick road. Trust me, it is so easy. It is easy as pie, and that's a roadmap. All written assignments are due Sunday. So business contract recommendations is what you're going to have. And then here's my motto, which I invite you still to take time to look at as well. And there it is, down there at the bottom. You click on it. Okay. So let's dive into, for the next roughly 30 minutes, 32 minutes or so, let's get into contract law. All right. Well, you already know about clicking on this, put your live classroom but assignment in, submit it for your points. Okay, you know that already. Okay, so some basic things in a contract. It's listed right here, and it's pretty straightforward. But let me, I'll add something to this that's not in here, and that is, first of all, contracts provide clarity to your transactions. And it also is important, as I said, to have contracts in writing. Contracts that are not necessarily required under the statute of frauds to go in writing, I still believe in writing. And it's as basic as some of the things that we're going to talk about today. All right. And one of the important things is that the minds must meet. The minds must meet. You must be touching and agreeing on the points of the contract. And usually is manifested by at the bottom that says you have signed it. And a lot of times contracts have some language in there that says you have read this contract, even if you haven't. The point, and because of the fact that many contracts that we utilize in this day and time are what we call boilerplate. That is, that they are standardized and we know what they are, such as a lawyer, when I read mortgage contracts, I pretty much know what's in there, unless, and I could glean through real fast, and then spot something, and I'll look for certain numbers and identification principles like the legal description and things of that nature. So let's talk about these points for just a few minutes. The contract is between two or more competent. That's one of the key things. Competent. We'll elaborate on that in a minute. For a lawful purpose. So it must be for a lawful purpose. It must be a person who is competent to execute a contract. Okay. And both parties must satisfy that requirement in order for the contract to be enforceable. So, number one, it must be based on mutual agreement. We already talked about that when the minds meet. Both parties must be competent. For example, you are aware, I'm sure, and can probably say it off the top of your head, that minors are not adequately competent to execute contracts. Okay. Can you think of another example or other examples of where parties are not competent to sign contracts other than minors? Can you offer one? Any? Yes, that's a good one. Intoxicated. Any other? There we go. You got them. Those are the two main ones right there. Mentally unstable. I kind of laughed though. Somebody said, well, mentally unstable is a relative term. No, it's kind of like you know it when you see it. Okay. but but yeah, you've been declared incompetent. Let's, for example, a lot of people become guardians, not of their children, but of their parents or other relatives, and you are um, able to execute a contract. Let's say, for example, a will. Um, the person who writes the will is not competent to execute the will at the time that is executed. Why? What's the deal? Why can't they? Tell me. It's right there in your face. What is it? The party whose will it is. Why can't they implement it? It's not a hard answer. It's easy. The question is, um, why can't a person who executes a will at the time the will is utilized um, be presented as a party competent at that time? We give you five, four, three, two, one. Because they're dead. Because they're dead. That's the answer. They can't speak about it. But that's why the will requires an executor or executrix. Executor is male, executrix is female. But now the times now the terms have become gender neutral. But the point of the matter is that that's why you have to have an executor of that will to take care of that. Okay, and generally that person is named in the will. All right, now, um, but the reason why a person who is a minor is not competent is because um, they don't have the capacity to execute the agreements. So, as you know, you can also have other issues. Everybody's familiar with the Britney Spears case, right? Who isn't, right? And her dad was her conservator for many, many, many years, and was over her affairs. She's an adult. She didn't really have any mental problems, but she had some issues that maybe she wasn't that good with money and stuff like that. So the point of the matter is that then uh, a court would then step in and appoint someone. But in the general course, it's the parents or guardian. That's why kids can order stuff on the internet, and if you dispute it and say, "Oh, um, my 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 kid cannot be sued for this," um, they could they could find themselves in juvenile court for fraud or for forgery. But as far as violating a contract, the person can't sue them. Even when they turn adult, they can't do it either. So at the time of the contract, that person must be competent. The promise made by each party must be supported by consideration. a lot of people think consideration is just money. Consideration can be goods, services, or other property. Okay. Now, if you ever look at a mortgage, um, the consideration usually is the amount of the loan. But let's look at it. Let's look at a deed, whether it's the mortgage deed, it's a quitclaim deed, or either a standard deed. Now, you'll see some language like $10 and other further and good valuable consideration. You ever seen that before? You seen that in the document? You ever seen that? If you ever seen a lease, you'll see it. But the good other further consideration is the dollar amount, which doesn't necessarily have to be stated. The point of the matter is that the promise must be supported by consideration. All right. It's not gratuitous. All right. Um, if I will say, hey, look, Shannon, I'm going to give you my bike. Okay. And you'll say, okay. And you come to me and you says, can I have your bike? And I says, no, I'll change my mind. I'm not going to do it. You'll say, wait a minute. You said you promised to give me your bike. I say, yeah, I did. But there's some issues that would be missing there. So, well, it's not just because it's verbal. You didn't have any consideration in it. Let's say, for example, Shannon, I'm going to give you my bike for $100, and you get the $100, offer it to me, and I don't give you my bike. Now, is that invalid because it's not in writing? No, it's not. No, it's not. And you'll learn in a few minutes why it's not. In just a few. It doesn't have to be. If you can prove uh, the fact that I said it and you have evidence, maybe you have an email, maybe you have a recording, of me telling you that, okay, you know, and you can produce that evidence. But you can be asked a lot of times about that. Now it's weak. The reason why I said it is I'm getting to a point. All right, and we'll hold that point for just a minute and we'll come back to it and you'll see why the answer to your question was wrong. It must be for a lawful purpose. Okay, so me offering to sell you my bike for $125 and I don't, that was an agreement. It was an oral agreement, and the consideration was $125, and the item transferred was also considered the bike. Okay, so was it for a lawful purpose? I guess it was. It didn't say it wasn't. So it was a lawful contract. Now, in some cases, here we go, it must be in writing. That's the statute of frauds. Okay. Now we're going to elaborate on that. Hold your horse, and we'll come to that in just a little bit. Once the 5 elements are established, one must decide what type of contract exists. And check this article. Okay, that's all right. Don't worry about that last statement. All right. So hold on the statute of frauds for right now. Okay, we're going to come to that. So let's stay with the elements of the contract. The offer and acceptance. There must be an offer. Did I offer to sell you my bike? Did I? Yes. Okay. Did you accept it? You probably said, okay. Now, one of the ways of proving that you accepted it is that the terms were that I will sell you my bike for $125. And you got the $225, attempted to tender it to me, and I said, I'm not doing that. Again, was there a meeting of the minds of the party about that bike? Yeah. Okay. Essentially, both parties need to be on the same page when you enter into the agreement. That was what I was talking about earlier. All right. In order for it to be valid. And the following requirements must be met. Tell me if this was met in that agreement that we just got through talking about. Was it a definite agreement? It was a definite agreement. I'll sell you my bike, and I gave the consideration amount, and you accepted it and agreed. So it was definite. It was definite. There was no indication. Just why I said what I said. You don't assume stuff. Just go on, and that's where people got to remember about law. You can't do that. You got to go with what you're given. That's why when you take tests and quizzes, when I took the bar exam, we had to go on what they told us. So it was definite. All right. It must appear to be seriously intended. That's another part. Now, I just said that to you. If I was just in joking, then that's a different scenario. But I'm saying, no, Shannon, I'm going to sell you my bike for $125. Get me $125, and I'll give you the bike. Conversations can be contracts. I'm telling you. I'm telling you. That's where people mess up. Okay. But anyway, we generally don't like them because they get messy. But what I'm doing is giving you the essence of the elements operating. That's what I'm doing right now. So hang on in there. Um, it must appear to be seriously intended. So did I indicate any way that I was joking about it? Okay, that's okay. Was it communicated to the offeree? That's the offeree is you. Was it communicated to you? Okay. So we're going to get into more details in just a few minutes, and this is something you can look at. All right, so just go with me right now on that for right now. One of the requirements necessary to enter into, so you have to offer and the acceptance is the capacity. We just got through talking about that. And must be competent at the time of the contract, as you already said, not intoxicated, not of mental capacity, or they are a convicted felon. Now, think about that one. I have seen people, they're starting to move away from that because you're convicted felon for, uh, let's say, um, battery, assault, a violent offense. Does that terminate your ability as a person to enter into contracts, do you think? Nope. So I don't like that statement. So it misleads people. It says, you're a convicted felon, so I can get out of this contract. No, no. So that is language that we have a lot of arguments about, but we correct that later because of other things that you're going to learn today. Contracts involving minors are of particular interest, especially entertainment industry. Um, anybody ever heard of? Oh, I'm drawing a blank on his name, but he was Willis in one of those TV shows. Trying to remember some. Oh, Gary, not Gary Cooper. Gary, because he's from Illinois. Um, Gary, he passed away now. He was a little short kid. Um, anyway, um, he was in the TV show Family Matters, or one of those. Little black kid. His name was Gary Coleman. Coleman, thank you. Thank you. Gary Coleman. Now, I'm aware of what happened with Gary Coleman. His parents were his managers, and um, he was the victim of them taking his money and utilizing it for themselves, and they were able to spend it. However, there was a trust account where the monies went while he was doing the TV show. But what happened is that they were over that, and then they utilized. So he had to sue them, and he was represented by another party to sue, obviously, and won. So in the entertainment industries, it's the parents who are well. I mean, though she wasn't a minor, it fits the same mold as the Britney Spears case because her dad is currently being sued. It's really unfortunate when you run into that kind of scenario, but particularly in the Britney Spears situation. But her dad was a rat. He was a rat. That's my opinion. And I was an entertainment attorney, and I did a lot of entertainment contracts. There was some allegations with Joe Jackson. Do you know who Joe Jackson is? I think he's still alive. Do you know who Joe Jackson is? Yeah, Michael, the Jacksons, their father. I got to know them because I lived in Gary for a little while, but they were kids. But I got to meet them later through my entertainment work and worked on some deals, not directly with them, but indirectly with them and their lawyers. I'm familiar with the fact that their dad was their manager and did a lot of things with them. Um, Venus and Serena Williams. Now, their dad didn't exactly take their money and stuff like that, but there was some issues with the dad as well. Did you see King Richard? Anybody see the movie King Richard? If you get a chance, see it. I saw it when it first came out. But that's the story about King Richard. Richard Williams is her dad, their dad, and it tells a story about how they shaped him up. But anyway, the point of the matter is there's a lot of these types of things. You can check that out. Consideration. An additional requirement of contract formation is consideration. And I already talked about that. The courts separate legally binding obligations from mere agreements by checking for consideration. Is the price that a promisor requires a promise? So that price of that bike was reasonable under the circumstances. Okay, so far as we know. All right, let's go and to leave this section. Now let's elaborate on it because I want to get into illegal and defective agreements. This is when it leads us into uh, the statute of frauds. Okay, now, first of all, written contracts, while safer than oral contracts, which we just got through talking about one, are fail-proof as not every contract will be enforceable. So it can, are not fail-proof, I should say, put that not in there. And even if all the requirements of offer and acceptance are met, it should fall due to it being an illegal or defective. Defective. There are also times when a third party becomes involved and thinks it should be included in the contract. So I put this in here already. The parentheses stuff, I added this to it. Now, there are certain times that a contract must be based on statute requirements. And we have what we call the statute of frauds, which came from England. Okay. And there are 6 elements to that. Okay. Now, did you get that information that I sent you about the statute of frauds? Did you get a chance to look at it? Okay. You got it though, right? No, it's an email. Here we go. Give me a second. I'm going to show you. Okay, so I'm going to show you the email that I sent out under messages. And let's go back to, here we go. The information pertaining to the statute of frauds. This is the email I sent out on the 13th to you. And it had 3 PDFs attached. So on the 13th, Sunday, it was sent out to you. It consists of a PDF. I'm going to open up that PDF for you. And this tells you all about it. And it's 6 categories. So I'm going to just save this for you. Remember, I talked about the 4 corners doctrine. Best practice, put contracts in writing. And then there are many loopholes. And then I list the statute for Illinois. So I added that to it. And then I gave you this one. This gives you some more explanation about how they operate and some questions for you as well. All right. And then this is the little worksheet that I sent you. It's all attached. So you're going to probably print that up and fill it in, the Y, the L, E, G, S. Now I'm going to take these out because I'm going to go over the topic. All right. Because this is a organized method for understanding this. But you want to get that because I sent it out to everybody, the entire class. So anyway, I take these, they're in order 1 to 6, but I like to start out with the number 5. Number 5. All right. Marriage contracts. Contracts of marriage. A prenuptial agreement. A prenuptial agreement, of course, is agreement in writing to divide the property if there is, we call it a just in case of divorce. It's kind of an oxymoron to me that it's like saying to your person that you're going to marry, just in case we don't work out, this is how we divide the property. It's kind of a funky thing to me. I never had one, but a lot of entertainers and professional athletes and people like that, when they marry someone, okay, and they have gotten in and put it, I guess it's fair in that sense there, but the bottom line is that a marriage contract, okay, so that must be in writing to be enforceable. That's why somebody said, oh, we got married, there is no document, we didn't get any license. It's not valid. Not valid. Okay. All right. So the next one is number 2. The contract cannot be completed within 1 year. The contract cannot be completed within 1 year. If the contract requires something that goes over that 1 year, then it is not going to be enforceable. Okay. So you got M, you got the Y. Okay, now you got the next word, legs, land contracts, contracts for real estate, mortgages, deeds, things of that nature. I'm going to sell you my house for $20,000, or yeah, I'm going to sell you my house for $20,000. Okay, and then you come to me and say, okay, here's my $20,000. You agreed to sell me your house. You weren't just in a joking. I said, yeah, but aha, the statute of frauds is my out. Now that means I can say okay and do it. However, though, you probably want to get a document of deed or something to make sure that I'm the right person and all that. You understand? You guys understand that part, right? You want to make sure that, I didn't walk down the street and sell you Joe's house across the street. Yeah, okay. But it must be in writing to be enforceable. And you know what happens with these documents is they get recorded, and the public can see who owns the property, their title searches and things that take place and all that. Okay, E, number 4, where the executor pays. Now, I already referred to this kind of a contract in which the executor or administrator pays the debts of the estate from their own personal funds. In other words, the executor, remember that who that is, that's the person who executes the will. An administrator does the same thing as the executor does in jurisdictions where there is no will. The statute in most jurisdictions provide for transferring property under the law, the way it operates, okay? But either way, the person who is the administrator, and the administrator generally is selected by the courts. The executor is usually named in the will in most cases. And if they pay out of their pocket for some bills of the estate, then they can submit those bills to the estate, and the estate is responsible for reimbursing them. Does that make sense? Okay. Now you have, okay, G, which is number 6, a contract for the sale of goods of $500 or more. Now, how much was my bike for? 100. It was 125, I think, but 125 tomatoes. So it's okay. I mean, we might have a dispute about that. So that thing. But anyway, the point of the matter is, is that you you got it. But so that's why, okay, the statute of frauds doesn't prohibit that, because it is not for goods 500 or more. So now it could be a total of, it could be a can of beans, but so many amounts of cans of beans that it equals 500 or more. If it's 4.99, it's in a different area. So the point of the matter is price determines whether or not, and the more valuable, once you get to 500 is deemed, you're over. Okay. All right. And the last one is suretyship, which is number 3, a contract to take on the debt of another. So can you name a suretyship contract? Can you think of one? How about a bond? How about a bond? Okay. How about insurance? So those are suretyship, whether it's life, property, or health. Except them health insurance policies, you got to watch them. Okay. But we have a phrase that goes back to the old business deal. And you ever heard of the term caveat emptor? Anybody ever heard that term? It means, literally translated, let the buyer beware. Let the buyer beware. I threw that out because the fact that that's what we tell people, but I won't get deeply into it because there's some other issues that go with that. But it's a phrase for you to be aware. So anyway, this all the only contracts that have to be in writing are the ones that fit within these categories. So my legs. And so if a written contract does not exist for the above stated scenarios, the parties run the risk of the contract not being enforceable. Okay, that doesn't mean it's illegal. It could be defective. All right. Now, email communications have been used to qualify a writing under the statute of frauds. And this was a Massachusetts case where they analyzed the nature of the agreement along with the substance of various correspondence, and they found that such communication met the elements of statute of frauds. You have to read that to get it. So the point of the matter is that now, uh, and so the point of the matter is that can do. So now here's a reflection question that I want you just to think about. How do you anticipate common law doctrines such as statute of frauds to be applied in future business environments? What types of communication do you think could fulfill these objectives? That's just a little food for thought. So now we don't have much time here, so I want to actually go ahead and almost wrap up, because the fact that we've almost covered everything we need to cover. As simple as that. Illegal contracts. The contract, remember I said it must be for a legal purpose. For example, mob contracts. Okay, you hear about them all the time. If the hitman fails to kill the boss, you are not able to offer up the contract in court to make it enforceable. The contract is illegal. Okay, and now you would be spending time in prison. The courts will leave the parties where they were enforcing the illegal contract. Contracts of gambling and things of that nature. So if it's for an illegal purpose, then it's not going to be enforceable. Okay, remember, it has to be legal. Defective contracts can make a contract void or voidable, depending on what area it is in the contract or the formation. Sometimes defect can be one-sided, which means it's unilateral, or mutual, where both parties have made a mistake. Let's say, for example, you decide that the contract is for a red car, and they bring you a white car and say, well, but you agreed to buy the car. Well, in writing, you would have it clarified. So you wouldn't necessarily have to go through with that. So that contract could be voidable, but not void. Illegal contracts are void. Voidable means the parties have a choice and they can still work through it. You got that? You got that one? Okay. Novation. This is the last thing we're going to do. Assignment or delegation are always which a third party enters. Typically, only the person who signed the contract have the right under it. However, there are times when one of the parties intends to benefit a third party. It happens all the time with contracts. It happens, let's say at the mortgage table, you sign with Bank of America at the table, and then you get ready to make your first payment, and it's now Comedy Bank has now acquired. And that means then that in the document, it gives them the power to transfer it. You can't transfer it because you can still be held responsible, but they can. Does that make sense? Because you'd have the same terms, inherit the same terms if you were the person taking over that. All right, there's some other issues involved in that, but we're not going to get deep into that. Trust me, it would make you like you're in law school. Okay, so very quickly, contracts are organized the laws are organized based upon whether there's a partnership or other relationship. Partnerships involve two or more persons engaged in a for-profit venture. Voluntary efforts related to goodwill do not qualify as partnerships. Okay. It should be noted that profit encompasses value, not solely financial or monetary gain. Like sole proprietorships, that's when you're the sole owner, are relatively simple, absent a controlling partnership agreement. And so there is a partnership agreement that goes along with it. And thus we have in the law what we call the Uniform Partnership Act. It is every state has a partnership agreement statute to control partnership agreements. All right. So there are what we call, and we're not getting too deep into this. Um, a partnership is formed as a result of written or oral contracts, either express or implied, in which the parties join together for a business venture. The two types are general and limited. So in the general partnership, um, uh, two or more persons who come together to run the business for a profit. Pay attention to that part. All right. In the limited partnership, two or more persons coming together under their state's limited partnership statute with one or more of the general partners and one or more limited partners. Now, as a limited partner, you would discover, if you do some research, and you'll probably discover this in your readings as well, which I know it's on the PowerPoints, that a limited partnership, if a person invests money in the partnership and become a limited partner, then they don't have say-so about it, but they can lose um, their assets in that. This is just general. Remember, we're talking about contracts in general, but they just threw that in. Okay, so that's it for today. But I do want to show you this information here. This is for yourself, flashcards. So we didn't talk about these things, but what's an option? An offer for which the consideration has been paid expressly to keep the offer open for a set period of time. And it'll say what that is. Okay, and so you can go on and you can go through and, okay. So then click on the card to see the other side. Okay, then drag it to the right. Then the next one comes. And you can do the same thing here. So I'm not going to go through these, but these are things that you can go through yourself. All right. So any questions? Okay. So did you learn something that you didn't know before today? Did you learn something you didn't know? Shannon, did you learn something you didn't know? Okay. Did you know about the statute of frauds? No. Okay. Okay. And what about you, Brooke? Brooke, you're quiet. Are you there, or did you just check in and do? I hope you're not doing like one of my students did. They checked in, and they used to tell me they would check in and they would listen, but they would be doing their laundry. And I told them, says, don't do that because you can't do that. Okay. Did you learn anything that you did not know, or some things? Okay, a lot. But the thing that is really cool, and many of my professors friends, they say, man, yeah, man, I never thought of using my legs in business law. Yeah, I use it when I was residentially teaching it. And I told them, I said, you'll always be able to remember. I mean, you can rattle it off like a 71-year-old man. Contracts, marriage, uh, a year or over, land contract, executive contract with executors paid, goods over $500, and then surety ship. Or bam, I remember, this is funny, uh, one of the guys that put on the bar exam program called the Barbary, I ran into him years ago, like probably about 5, 10 years ago, because I retired in 2000. I ran into him, and his name was Mike Spack, and he was a professor at IIT, Illinois Institute of Technology, Kent College of Law. And I said, "Hey, Mike, how are you?" I says, "Doing okay." I says, "My legs are doing fine." And he started laughing. And he didn't realize that. He said, "Well, good. It's been years." I said, "No, no, my legs." And so when I started writing it off, he says, "Wow, you still remember that?" I says, "Because that's an organized way. I never would have remembered it other than that because it gave me a mnemonic. That's what mnemonics are good for." All right. So, but you'll be able to say, "Yeah," and you got that little sheet there. So if you're sitting down thinking, even as a lawyer years later, um, and representing people. I mean, I didn't have to think about it so much because the contracts were brought, but that's it. So anyway, statute of frauds is the phrase that I want you to give to get your points. Okay, make sure that you capitalize statute and frauds. It's not statute of fraud, statute of frauds. Okay. Um, So give me statute of frauds and you get your points. Okay. All right. So again, this I enjoyed this session. So I will see you next Wednesday. Stay safe. Uh, um, thank you. I think we're going to be snowed in. Are either of you in Illinois? Either of you in Illinois? Oh, okay, but you don't have to worry about that. Oh, Brooke, you might. You already, I mean, you always having snow. Okay. So, yeah, you always have snow. Do you have a lot of snow up there right now as we speak? Not really. Okay. Well, we're getting ready to get a blizzard here in the Chicago area here. Excuse me. Not as bad as the one out East Coast a few weeks ago. I think they had the worst snowstorm out there on the East Coast than I've ever seen in my entire life. A few weeks ago, you know what I'm talking about. So, all right. Well, anyway, I know it didn't stop actions in Washington D.C. Stuff still continued to happen in the nation's capital, regardless of that stuff. So, see you next week. Stay safe. Enjoy, get those assignments completed, and if you have any questions, reach out to me. All right, take care.